I'm being told we're going to hit a break since the judge apparently is just taking a pause here, maybe taking it all in, deciding what he's going to take up first. We'll do that, and we'll go back into the courtroom live and watch this hearing, the final hearing before Donna Adelson's trial.
Matriarch of the Adelson family gets arrested.
Terrible.
Donna Adelson is facing charges of murder, the death of her former son-in-law, Dan Markel.
Prosecutors say a bitter child custody battle was the motive for the murder-for-hire plot.
Now that Donna has turned into a defendant, what's next for the Adelson clan?
Now that the ship is really sinking fast, blood doesn't matter that much.
The Matriarch Mastermind murder trial. Live coverage begins August 19th, only on Court TV.
Making mistakes. No mistake. It's two mistakes.
We're getting ready to watch together the final hearing before Donna Adelson's trial. She's accused of conspiring with her son Charlie and others to carry out the murder of her former son-in-law, Danny Markel. He was married to Donna's daughter, Wendy Adelson. She has not been charged, but that could always change. Let's go into this hearing now. The judge has just taken the bench, and he is ready to take up these motions.
Here this morning in State versus Donna Adelson, 2023 CF 3226. For the final pretrial hearing this morning, we're going to address all of the outstanding motions and also some matters pertaining to the trial, which is still scheduled for the selection of the jury starting on August 19th. The parties can make their appearances for the record.
Georgia Kappelman for the state.
Jackie Fulford for Mrs. Adelson.
Joshua Zellman for Mrs. Adelson.
Right. I believe we have several defense motions to address. Ms. Kappelman, the state has not filed any additional motions in limine that have not already been addressed by the court.
That's correct, Your Honor.
All right. Let's start then with the motion in limine concerning the court file relating to the dissolution of marriage. Mr. Zellman.
Thank you, Your Honor. Your Honor, as is my custom, I lay it out in the motion. It's our position that the vast majority of the court file, even with the court taking judicial notice, is inadmissible. It's irrelevant. Paragraph 7 of my motion provides a somewhat comprehensive list of the items that are in there that have no bearing, have no relevance. They're not material in any way to this case. And so we're asking that, aside from very limited number of items that the state can establish has relevance and is not barred by hearsay, we're asking that the court exclude that file.
Ms. Kappelman, which parts of this file is the state seeking to admit as a part of its case in chief?
The entirety.
Right. As to the items that deal with, as identified in paragraph 7 of the motion, what exactly would be the relevance first, and what is your argument as to hearsay?
For relevance, Judge, it goes to the motive, the level of intensity of this litigation, the volume of the paperwork suggests that it was very litigious and went on for some time. The words that are used are strong, even hateful, and this was a cause that was adopted by the defendant, as the emails evidence will show. So it's important for the jury to understand the foundation of this motive is this litigation that began with the divorce, continued beyond the divorce with the child custody issues that developed later.
All right. So in part, the volume of what occurred over the divorce proceedings, you want the jury to recognize this goes to motive in some way.
Yes, Your Honor. In reference to hearsay, The items are not being offered for the truth of the matter asserted. There obviously was a litigious divorce, but it's being offered to show the effect on Ms. Adelson. These items were shared with her. The evidence intends to show she was very involved in the pleadings. She was sent the pleadings and offered detailed responses for how Mrs. Wendy Adelson should respond to the pleadings. So it's very bound up in the state's theory of the motive for the case.
All right. Mr. Zellman, as to your client's emails to her daughter as this litigation was going on, are these contested in any way?
With respect to the initial dissolution proceeding, no. However, in reviewing the emails, the post-dissolution matters that were filed by Mr. Markel, there's no evidence in those emails that those pleadings were shared with Mrs. Adelson. And so certainly, if the state's theory is that it goes to the motive, and that's their way of getting around hearsay, they have to establish that the pleadings were sent to her. My review of the emails show that did not happen. So they can't go to show my client's motive if she didn't receive that.
All right. As to any pleadings that correspond with emails or communications that were made by the defendant and otherwise demonstrate her role in or some part in the divorce case, as to those, I'm going to rule they are admissible. The pleadings themselves, if they're being offered not for the truth of the matter asserted, but to otherwise demonstrate motive or intent, those are admissible. However, Ms. Kappelman, as to the bulk of the file itself, I do believe the defense is raising a clear point on this. Absent a connection or a nexus between the defendant and specific aspects of the divorce file, what is your argument concerning it?
There are pleadings in there that are not necessary to show the motive, but I did offer the exhibit itself in its entirety to demonstrate the bulk. If Your Honor is not inclined to allow those pieces of paper that cannot be directly connected to the defendant, may I be permitted to show the exhibit as a demonstrative to the witness to verify that that is the entirety of the divorce file?
It is permitted as a demonstrative. You may also ask questions that generally deal with the amount of filings and also the volume of the case, but ultimately as to responses for production or mediator notices, I'm inclined to agree with the defense as to that point. If there's not either a relevant connection or a nexus between the defendant's actions and then what occurred in the dissolution of marriage case, all of it does not come in as substantive evidence. But I do want to make clear on this point, Mr. Zellman, as to what the witnesses will testify to, and none of us will know this until the evidence actually begins. This file can be used for purposes of impeachment, and it can also be used for purposes of rebuttal. Depending on what the witnesses say, what might be not a part of the state's case in chief may still be available to them through other means that are permitted by the rules of evidence. Is everyone clear on those?
Yes, sir.
Yes, Your Honor.
All right, let's move on to the motion of limine concerning the testimony of Sarah Youssef. Mr. Zellman.
Again, Your Honor, we stand on the motion.
Ms. Kappelman responds.
I would just ask Your Honor to reserve on her. The state has no intention of calling her, so I don't think, unless that changes, that there's any reason to address her testimony at this time.
Well, and I assume you are going to leave Ms. Youssef available as a rebuttal witness if necessary?
Yes.
If a witness is not going to be called, it essentially moots the issue. On that point, Mr. Zellman, The state is not committing to calling this witness. If they do call them at that time, I will issue a ruling concerning your motion in limine.
Yes, sir.
As to any purpose of rebuttal, ultimately what comes out as a part of the defense case, Ms. Yusuf still is able to testify in that capacity. All right, the next motion in limine concerning the testimony of Stephen Webster. Does the defense have any argument that has not already been made through the pleading?
No, Your Honor.
Ms. Kappelman, response.
Judge, I agree with some of the defendant's motions. I don't think Mr. Webster can offer opinions. For example, his testimony, of course, will be governed by the same rules of evidence that every other witness is governed by, but he does offer some relevant points, so I think I should be permitted to, I don't know, these motions kind of blow my mind because it's like we want to pre-litigate every statement, including potentially objectionable statements that can be addressed during the trial by a proper timely objection, so I would ask that it be handled in that way.
All right, concerning the testimony of Mr. Webster, Mr. Webster, in his capacity of representing the deceased, certainly can testify factually as to what his involvement was with the divorce case, and also he may testify concerning the nature of the proceedings as to any opinions that go beyond that. Ultimately, I think that's where we are going to have to get into what is being asked and what would be the response that ultimately the defense would find objectionable. But generally, as to any opinion that Mr. Webster cannot give without a proper foundation, I think it's settled as a matter of evidence that no witness gets to generally opine on matters in which they are not qualified to testify to. Is any other ruling being sought concerning Mr. Webster beyond that by the defense?
Well, yes, Your Honor. In prior trials and in deposition, Mr. Webster testified about statements made to him by Mr. Markel. Those are hearsay. There's not an exception. Those statements weren't shared with anyone else, certainly not my client. Those were statements that were made during the meeting in May of 2014 that Mr. Webster. There's no exception that I'm aware of under the hearsay rule for
statements made by the deceased to Mr. Webster. Ms. Kappelman, do you have an argument?
I think I agree in general that those statements would be hearsay. I don't recall what my theory of admissibility was in prior trials, but I would agree to approach if I intend to elicit a statement made by Mr. Markel to his attorney and offer my theory of admissibility prior to asking the question if I decide to do that in this trial. I don't think I plan to do that, so it's hard for me to address what that theory might be now.
Very well. Again, as a general principle of evidence, hearsay that has no exception is not admissible. If the state is seeking to admit this statement for a proper purpose that actually has a basis in the rules of evidence to be admitted, you will need to approach so that way the information is not placed improperly before the jury. The motion in limine is granted as to Mr. Webster offering any opinions for which he is not qualified to give. The court will reserve the ruling on the issue of any statements that he may testify to by the deceased if the state, again, will have to present an actual exception to hearsay in which the matter can be placed before the jury. All right, the renewed motion in limine concerning the Latin Kings.
We're going to hit the pause button right here. This next motion should get interesting. We'll watch it together live right after this quick break. was when Donna Adelson was first taken into custody. Welcome back to Court TV Live. I'm Julie Grant. This morning, she is attending the final pretrial hearing before her homicide trial begins on August 19th. And so this is a chance for both sides to put before the court any last-minute issues that they need a ruling on. Her defense team is doing a great job, I have to say. They are trying to keep everything out that is damaging to her. So that's their job, right? Their job is to advocate for her. And this prosecution team I've commended throughout the progression of them handling these various cases to get justice for Dan Markel. They're on the ball too. So when we last left off, the judge said he was about to take up a defense motion. This has to do with mention of the Latin Kings gang. Let's listen.
Mr. Zellman?
Yes, Your Honor. This goes in part to the theory of the defense and why Mrs. Adelson acted the way she did, the language that she used on the 2016 wire calls. Typically, I know that we would want to have the foundation laid through her testimony for that, but if the court were to bind our hands in questioning the state's witnesses, it would be too late to wait until she testifies. We would lose the ability to cross the state's witnesses on that issue. It's very limited. You have Luis Rivera. There would only be a few questions at most. Potentially Charlie Adelson, depending on when the state calls him. Certainly Special Agent I believe it's Jimenez.
Now, in the last trial, he outright testified that he was, I guess, at least pretending or trying to influence your client, a member of the Latin Kings gang.
Yes, sir.
All right. To that end, Ms. Kappelman, what is your argument?
Same as my argument has always been on this issue, Judge, which is that Rivera was a gang member. That's why he was recruited to do this. I think that's relevant. But the fact that he was a leader of a specific gang, I think, is just bad character evidence that doesn't lend anything additional, more prejudicial than probative, and I would ask to exclude those details.
Similar to what we had in the last trial, as to this painting the character of Mr. Rivera specifically in a negative light, the court's ruling will remain the same. As to the witnesses, though, Mr. Jimenez or other witnesses that may bring up this topic unsolicited on their directs, once the horse is out of the barn, it's out of the barn. As far as any cross-examination of Mr. Rivera specifically, the defense may cross-examine Mr. Rivera as to his role as a gang member and why he was recruited into this matter to specifically serve a purpose as it relates to the conspiracy of the killing of Dan Markel. Now, with regard to undercover or the former undercover agent, Ms. Kappelman, this is where I believe the analysis begins to diverge on this topic. He specifically approached the defendant as a Latin King member, correct?
No, sir. My recollection is, I know that was his testimony, but and I would instruct him not to say Latin King in the future. However, he didn't say anything to Ms. Adelson about being a Latin King. I guess that was his version of acting like a gang member. I don't know how well he did. Ms. Adelson didn't seem to think he did very well, but that was the intention. He did not represent himself to her verbally as a Latin King gang member. He was not wearing any clothing or other signifiers that he was a member of a specific gang. I think the idea was just, you're an associate of this killer who is a gang member.
In response on that topic, Mr. Zellman.
Just looking at his previous testimony. My role, I'll quote from page 1067 of the trial transcript in Mr. Charlie Adelson's case, starting at line 20. Question, can you explain what that operation was? Answer, my role in that operation, I was portraying a Latin King gang member, and I was instructed to conduct the bump. Continuing on 1068, question is, all right, when you say you were posing as a Latin King gang member, did you announce yourself as a Latin King gang member to the person you approached? I did not. Okay. So you're just, that's the role? That was my role. You're in character? That is correct. That is his testimony. And yeah, I believe that once, especially with the call that my client made to the undercover on May 6th of 2014, when he became verbally aggressive towards my client, that factors into his role as a Latin King gang member. And I know in the previous hearing last year, Your Honor questioned whether there was a difference between a Latin King gang member and simply a gang member. The answer is absolutely. In Miami, in South Florida, there is absolutely a difference between a gang member and a Latin King gang member.
Even with that being said, this ultimately goes to your client's state of mind and who is going to establish how she knows the difference between, forgive the pun, the garden variety gang member and a specific gang member.
I think between her testimony and anticipated testimony of Charlie Adelson.
All right. As to the questioning of the former undercover officer or special agent Jimenez, I will permit the defense to question the former special agent as to whether he is portraying a member of a specific gang as a part of his bump operation. Depending on what the answer is, we'll revisit the issue of whether the name Latin Kings needs to be specifically uttered as to either Mrs. Adelson or Charlie Adelson testifying concerning her state of mind and knowledge of the Latin Kings. As it goes to state of mind, the defense may certainly inquire as to that during the defense case in chief. As to Luis Rivera, the court's ruling will remain the same as to his leadership role or specific affiliation. The fact that he is a gang member may be inquired into, and the fact that he has had, or the fact that or his role while he was recruited in this case, that certainly is ripe for cross-examination and may be inquired into. But as to him being a specific Latin King, that is where the line is going to be drawn. Do we need any clarification on these rulings?
Just a moment, Your Honor.
Not from the state judge.
Okay, so the judge is giving them some latitude, saying, sure, you can ask him about his membership in the gang, his role regarding the undercover agent, but we're not going to get into specifics about the Latin Kings and his role in that gang. All right, Judge kind of split the baby there with that issue. Let's see what our legal analyst guest thinks of that. Attorney Rick Grundy watching along with us. Rick, what do you think? Right ruling with respect to Luis Rivera? We know this is a key witness, somebody who's come a long way. We know he had involvement in the hit and then has been used as somebody to provide information for the prosecution from, you know, I guess it's been, geez, almost 10 years now.
Yeah, I think it's a good ruling. I think it's a fair ruling. You know, for any folks that aren't fully acquainted with the gang memberships, Latin Kings are not only throughout our nation, they are entrenched in numerous nations, and very much so. They are the largest single Hispanic-oriented gang in Massachusetts, as they are in Florida, as they are in California. So if you were to get into the weeds on this, the testimony of a gang member lends a credence of they were serious about this. They were looking for the kind of people that you imagine get involved in murders. The difference between gang member and Latin King here would be if I were to tell you I'm looking for some financial advice and I went to Merrill Lynch and secured Merrill Lynch's help as opposed to Johnny Q down at the corner. If you hear me say Merrill Lynch, you're going to be serious about this. He's got some people who are known for doing this and have some credibility in getting the job done.
Yeah, that's a good analogy you share with us, Rick. Thank you for that. Here's what we're going to do. We're going to hit a break. When we come back, we'll see what the next motion is to be taken up. As I told you, this defense team doing a great job. They're bringing up every issue that they think could potentially be harmful to Donna Adelson's case. Stay with us.
A woman's remains found scattered throughout a 3-mile area.
Now, a former naval officer stands trial accused of killing his wife.
The dismembered wife murder trial. Live coverage today on Court TV.
These are the cases that captivated the world.
Couldn't keep my life straight.
They were killed by their own children.
That challenged the legal system and ourselves. Court TV, Legendary Trials.
Back into the courtroom we go. We're in Florida this morning. This is the final pretrial hearing before Donna Adelson's homicide trial over the murder of her former son-in-law, Dan Markel. Let's go back into the courtroom and see what the next motion is.
The concern we have, Your Honor, is that Mrs. Adelson, part of her state of mind, her level of fear, is that it's not just that she learned he was Latin King, but that he was the leader of one of the branches of the Latin Kings in South Florida. That heightened her fear. And of course, she will testify to that.
I cannot make her testify. If she is committing to do so as a part of her defense, that's her choice. But ultimately, someone with competent knowledge has to testify to this fact. Eliciting information about state of mind from the witness that either has not spoken to your client or either has no knowledge of the state of mind, I'm not sure how that can be accomplished other than either your client herself, her son, or someone else who has direct knowledge of her state of mind at the time, unless you have an argument.
So I guess the way that we could accomplish that, Your Honor, is that Mr. Rivera, he is under a defense subpoena. We would ask that he remain for the defense case so that we can call him on our case in chief.
That's fine. Mr. Rivera, as I recall, never had any direct communication with your client, but this is to elicit another relevant matter.
That's correct, Your Honor. It would be, once we establish the foundation, I would want to recall him for the specific purpose of him confirming that he was a leader of the Latin Kings.
Very well. Mr. Rivera will remain under the defense's subpoena until the conclusion of the trial. Let's move on to the defendant's motion of limine as to the interpretation of emails, recorded phone calls, and text messages. Which witnesses is the defense referring to concerning?
Okay, we need to stop and back the truck up just a moment here because there was something that came out. If you were listening really closely, I know you caught it. Like I did here, did you hear Donna Adelson's defense attorney when he was talking about how his client Donna became even more fearful when she was confronted by this person because she learned that Luis Rivera was a leader in the Latin gangs, and that made her even more fearful because of his high rank. And then the lawyer said, and she will testify to that. So we have no confirmation that she's going to testify, but you just heard him say that. I think that's a preview of what's to come, my friends. Now, of course, she can change her mind, you know, up to the last second when the judge asks her if it's her wish to testify and advises her of her rights. But up until now, nobody from the defense team has told us anything about whether they're going to call her to the stand. And you just heard the attorney say she'll testify. And he said they're going to put on a case, too, calling Luis Rivera, perhaps as witness number one, to ask him about being a leader of the Latin Kings. Let's bring in attorney Rick Grundy. And I know you caught that, Rick. You don't miss a trick there. He said she will testify to it. Do you think this is going to be smart for Donna Adelson to get up there and testify?
You know, I feel that Donna Adelson will fall into that category of, oh, I guess I'm not as smart as I thought I was, and not do herself any favors on cross-examination. Let's also take this in light of the fact that the defense counsel is appropriately trying to get some rulings in place during the Commonwealth's case. In doing so, he proffers that she will testify to establish this, that, or the other thing. This, that, or the other thing may be established by a witness prior to getting to that. And also, I know my good friends on the defense side, when I was prosecuting homicide cases, they never wanted to take away that potential that the defendant was going to testify, because they liked the way it made Rick have a little more anxiety about the case and maybe put a little more time into preparing something that wasn't going to happen.
Sure. No, I hear what you're saying, Rick, and that's a fair point. You know, he can be saying this, and then at the last second it can be, oh, you know, we changed our mind, all of that, just making everybody think she's coming in. I said before, because believe me, I'm no fan of defendants testifying. They rarely help themselves, as you know so well from all of your experience. In her case, I'm looking at her age and how she's somewhat removed from the allegation, you know, physically not there, and geez, I think she's number 1, 2, 3, 4, 5th to be tried. I'm wondering if at her age she rolls the dice, you know, and just says, what the heck, let me get up there, try to seem endearing to the jury, try to seem like a sweet grandma. I don't know. I'm almost out of time here. Rick Grundy, quick final thoughts. You don't think it's going to go well, though, if she does, huh?
I don't. I agree with you that there's a far more likelihood that she will testify as opposed to others, for all the reasons that you just stated. You know, the idea that you're the smartest person in the room gets you on the stand, and then it hurts you once you're on there. So that would be my prediction for Donna.
Rick Grundy, you're wonderful. So great having you on the show. Thanks so much. We'll hit a break. We'll be right back with more of Donna Adelson's motions hearing.
Adelson? How you doing? Just want to give you this. Can I ask you, is someone blackmailing you? No, it's always a possibility.
I said to Harvey, I swear to God, our family was cursed.
When did they issue a warrant?
One moment, Miss Adelson. Please keep your comments to yourself.
This is Court TV Live. I'm Julie Grant, and we're so grateful for your company this Friday morning. We are in court in Florida at the final pretrial hearing for Donna Adelson. Her homicide case is set to go on August 19th. That is when they're going to start picking the jury. And so we're a little less than 2 weeks away from that. And so this is the time where the attorneys have a chance to put before the court any last-minute motions that need to be decided. So we're going to pick up where we left off in our last hour, the judge taking up the next motion. Here we go.
I think it goes really to retired Detective Isom, Special Agent Sanford, potentially Jason Newland. I think a number of witnesses have offered interpretation of statements that were made. Now, we're not talking about coded language. Coded language is treated differently. What we're talking about is the emails, the recorded phone calls, and the text messages, other than coded language. What we're asking of the court, because it has come out so frequently, that the court prohibit the state, and, you know, what's good for the goose is good for the gander, the defense, from asking someone other than an expert to offer an opinion about what someone means by an email, what they meant by a statement, or what they meant in a text message, aside from the language that's used itself.
Ms. Kappelman, response?
I agree, that would not be admissible.
The motion in limine is granted as previously raised, and the argument on this matter, any matters that would go to a code in which a witness could lay a proper foundation on this issue. Certainly they may testify as to that point, but any general opining as to what an email, a phone call, or a text message means will not be permitted unless there is a proper foundation that can be laid by that witness. Next, the defendant's renewed motion in limine concerning travel as consciousness of guilt.
Your Honor, I know that the court has previously ruled on this issue and that allowed the state to use this information in their argument. The new information, as I laid out in paragraphs 4, 5, 6, and 7, I stand on the motion. Those additional pieces of information had not previously been provided to the court, and I think that it's significant because it goes to her state of mind for making the travel plans and for going to the airport and for stepping onto the jet plane.
If I'm recalling prior counsel's argument correctly, Mr. Rashbaum did raise the fact that there was no legal process, subpoena, or warrant for your client, correct?
I believe that's correct, Your Honor.
Well, response, Ms. Kaufman.
Judge, I don't think this is new information. This was never disputed. I don't think it changes the analysis.
On this particular point, the court has reviewed the transcripts of the depositions that were cited by the renewed motion, and the ruling will remain the same on this issue as before. These matters go to the weight of the evidence and not the admissibility. The jury, as the trier of fact, is going to decide what significance to give to the evidence. The defense also is free to cross-examine on all issues that pertain to Mrs. Adelson being free to travel. The matters that have been previously raised within the motion to suppress and ruled on as to the phone calls and other evidence, that also will be presented to the jury as well. They will make up their mind.
Thank you, sir.
Well, I believe that covers the defense motions. And Ms. Kaufman, you stated that the state did not have an additional motion in limine that had not already been previously ruled on.
That's correct, Your Honor.
Judge, there's one additional one also filed on July 21st concerning the opinion testimony of Jason Newland and Patrick Sanford.
Oh, yes. Go ahead as to that motion.
Sorry, Your Honor. I'll stand on the motion.
Ms. Kaufman, response.
Judge, the defense elicited personal opinions of these witnesses at deposition about the lawyers and their ethics and how they think they might have been involved in the new investigation, and now seeks to suppress those opinions, which are clearly inadmissible. I don't understand it. I don't know why we're doing it. I would never elicit such a thing.
Well, Ms. Kaufman, even though it might be inquired into at deposition, ultimately, if there's a basis to exclude it pre-trial, that's why it's being raised now.
Of course. There is no reason to elicit it at deposition, and then it could never be admissible at a trial. So we're just wasting paper and time with these motions. No objection.
The state is conceding the issue. The motion is granted as to any opinions that would be offered by either Investigator Newland or Special Agent Sanford. Again, there must be a proper foundation for them to offer an opinion on a subject if they don't have the ability to do so. It cannot be presented as a part of the case in chief. I don't really see a context in which this might come around either in rebuttal or as far as impeachment, but again, these rulings are being made as to the state's, the substantive evidence the state may present as a part of its case in chief. If it needs to be readdressed as a matter of either impeachment or rebuttal, we'll take it up at the appropriate time. All right, let's go ahead and talk through some of the logistics for jury selection on 8/19.
Okay, now they're moving on to jury selection. Let me get some quick thoughts here from our guest analyst, Attorney David Gelman, criminal defense attorney, now former prosecutor. David, good morning to you. That last little issue taken up, curious what you think about that. Defense counsel, it sounds like, asked for some opinions during depositions, which can be done in Florida, but is concerned that these opinions are now going to come up in the courtroom and that the state's going to introduce them. Yeah, what are you thinking, please?
I'm thinking exactly what the prosecutor's thinking. Why are we arguing this? Why are we wasting our time? I mean, they're conceding. It is wasting paper. That's exactly what the prosecutor said here. There's no reason to bring this up. I think the defense is either just grasping for some straws here, or they're trying to make it look good for their client, Ms. Adelson, because look, we know how she is so far. She's already filed counsel before. She probably could do it again if she wanted to. They're just literally grasping for straws. There is no reason to be arguing these mundane points when the state already agreed to it, and I'm sure they already talked about it beforehand. So I'm with them.
Yeah. You know, David, let me ask you this. Being a trial attorney, and you've been on both sides of the courtroom. You do defense work now in the private sector. You've served as a prosecutor. You know what it's like to be in the trenches. You know what it's like to have that final hearing. You know, everybody gets to that final one before the trial where you want to put your best foot forward, right? The things that are most important. You know, to your point you made a moment ago, if something's mundane and really doesn't matter, do they run a risk of annoying or upsetting the judge here?
Julie, great point. Yes. And you could kind of see with the judge's tone a little bit at the end where I don't know if he thought it was funny or he's just like kind of exhausted by the defense's tactics here. But yeah, you got to, be cool with everything because look, the jury is the one that's going to ultimately decide the case. However, you better be on the judge's good side because he could rule against you multiple times for things that, might be avoided if you didn't annoy them all the time with these mundane, motions, if you will. Look, judges don't want to be doing this on a Friday afternoon, just like anybody else wouldn't want to do it. So they really could have had this housekeeping stuff done way before this, and they probably could have been done by now.
Definitely, David. Yeah, that's a great point. Pick those battles. Like you were saying, if this is something important, address it. If not, think about the judge's time. It's Friday, it's the weekend. Maybe he likes to golf. Who knows? But I know I was always thinking about my judges. I know you do too with the ones you practice in front of. It's like, if I know they're going to be wanting to get this done, I'm going to be brief and precise. David, I'm so glad you're on the show today. Stand by kindly, please. We're going to hit our first break of the hour. When we come back, we're going to talk about some of the concerns with jury selection. We know this is a really high-profile case. And think about where we were 6 years ago, my friends, when we saw the first of these cases going to trial. Progressively, the state of Florida has indicted more and more people for the murder of Dan Markel. Is Donna Adelson one of those people? That's going to be the question for this jury. We'll watch more of her motions hearing when we return.
Vegas, stand up! Friday nights, the WNBA is on Ion. The Liberty face the Wings. Then, the Aces host the Storm. She was feeling it. Coverage starts tonight at 7. Find Ion wherever you watch. Ion, it's on.
A woman's remains found scattered throughout a 3-mile area.
Now, a former naval officer stands trial accused of killing his wife.
The dismembered wife murder trial. Live coverage today on Court TV.
Welcome back to Court TV Live. I'm Julie Grant. We're going to go back to Florida together in just a second. I want to let you know we've got another trial we're broadcasting today, the dismembered wife murder trial. It's happening in the state of Georgia for defendant Nicholas Casotis. Here's a live look inside the courtroom. He looks like one of his lawyers, and he actually is a lawyer by profession. No longer practicing. He served in the Navy JAG Corps and then left that position for unexplained reasons. Maybe we'll get an explanation if he testifies. He's accused of murdering his wife, Mindy, and dismembering her body. His defense team says that they were on the run because someone was putting them in fear and controlling their movements, and that someone else killed and dismembered his wife. We're streaming this trial. If you want to take a look at what's going on in the courtroom right now, by all means, go to courttv.com. You can do that. And then when we're done with Donna Adelson's hearing, we will show it to you here on your TV. Back to Florida now we go. It's time to talk about the jury selection process for the trial that kicks off August 19th.
We are going to be in this courtroom once again. I believe the number of jurors that we have under summons right now, or prospective jurors under summons, I believe it's near 300. So what we're going to do on that Tuesday, essentially, we will have the pre-screen of the jurors on the issue of pretrial publicity, similar to what we did in the last trial. The court will be asking the same questions, or substantially same questions. Both parties will have an opportunity to follow up on the court's questions on the issue of pretrial publicity. If a prospective juror is deemed suitable to return for a group voir dire, from there, they will be given the date and time for which group voir dire will begin. For the pre-screening that will take place on both Tuesday morning, Tuesday afternoon, potentially Wednesday morning and Wednesday afternoon, I would anticipate by that point we would have a suitable pool of jurors from which, going through the pre-screen process, anyone who has had an issue, or either the court believes, the state believes, or the defense believes, is not suitable to go to the group voir dire. From there, each party will have an opportunity to make their objections known as to that prospective juror, and either they'll be told to return or they will be excused at that point. Does anyone have a question about the pre-screening process?
No, sir.
There you are. Also, as well, so that we don't have any issues similar to what occurred in the previous trial, in which I believe there were allegations the jurors were speaking to each other. We are going to have additional bailiffs. The prospective jurors are going to be instructed not to speak to each other. It might make a long day for them, but they will be sitting in silence. We will provide reading material to them, and we'll have extra bailiffs on hand to ensure that no one is speaking to each other while they're waiting to be screened. Does anyone have anything they need to raise concerning those?
Is it your Honor's intention to handle the pre-screening, I don't know what it's called, instructions that happen down in jury assembly?
Yes.
Okay.
I believe last time, I'm not sure if someone else qualified or not, but for each group that will be qualified, I will do it personally, so that way from beginning to end, they're seeing me, hearing me, and understanding you're not to discuss the case or anything else with each other.
Perfect. That's the state's request.
Judge, how many of the 300 are coming each day?
Broken up into groups of 50. So 50 in the morning, 50 in the afternoon. We may not even need to get to the end of this grouping altogether if we are able to go through the pre-screening process on the issue of pretrial publicity. Once we have, say, 100 to 110, that's more than enough to get 12 people.
How do you intend to handle proceeding once we successfully select a jury?
Once we have selected a jury at that point, and also I believe too, we'll need at least 2 alternates unless the parties wish to have 3.
Defense would request 3, Your Honor.
Very well. Then once we have our 12 jurors and 3 alternates, at that point we will swear them. If we have enough time to actually move into opening on that same day after the selection, we'll do that, so that way we can start to begin into the witness testimony seamlessly without issue. How many days is the state anticipating to go through its case in chief?
I think best case scenario is 5, worst 7. So 6. I could see how it could run into the first part of the 7th day, Judge, but I think 6 is a comfortable estimate.
All right, let me bring up my calendar. Right. Assuming that we have a jury by Friday the 22nd, then really that would place August 25th through September 2nd as the state's case in chief. I think there is a holiday on September 1st, correct?
Yes, sir.
Yes, sir.
Is anyone volunteering to work on Labor Day?
Jackie is.
I need one other hand, unrelated to that side of the table.
Thanks.
It is a holiday for the workers of the world, but we cannot forget that we have a trial to finish. All right, 8:25 through 9:2, then, or estimating as the state's case in chief. How long is the defense estimating to present any case that it wishes to do so?
Can I weigh in on that before they speak, Judge? We have historically picked a jury in 3 days at the longest. Twice we did it in 2 days. So my suggestion would be to start on Friday. We could even do openings as early as Thursday, if Your Honor was willing to entertain that. I know that's not the defense's request, but that would be the state's request, just to move it along as quickly as possible.
Well, for the openings only, does the defense have a position concerning this?
Judge, we don't want to make openings unless we have a great deal of time after we pick the jury on a particular day. We would prefer to do the openings the next day.
So you're not asking to defer your opening to your case, you just don't want to open on the same day?
It's going to depend, Judge, on your ruling on the additional motion.
All right. On that matter, again,
I just love Judge Stephen Everett. You know, he is a great judge. He knows how to run the trial. He is sharp. He knows the rules of evidence. He probably knows the facts of this case. He could recite them off the top of his head. He's heard it so many times. How considerate he's being of these lawyers. I have to tell you, the fact that he's asking them what their preferences are for the opening statements. Really, really considerate. That's not always the reality in courthouses across America. Let's bring in our legal analyst guest, attorney David Gelman. He's in the private sector as a criminal defense attorney now, has served as a prosecutor as well. David, I keep thinking, wow, to get a choice, that's really awesome, isn't it? What's reality like many days?
You know, I really was, I'm thinking the exact same thing. I'm really impressed with this judge right now. You know, I think he's got a handle on everything, and that's exactly what you want. You want to have a judge that controls the courtroom, because that is their place. That is their home, if you will. You're a guest in the judge's courtroom, and he is telling you this is how we're going to do the trial. I love it. Now, have I really ever had any judge tell me, well, do you want to do openings this day or this day? No, that's not really how it goes. The judge usually says, all right, after you guys have that jury, you better have your openings ready. So I was a little surprised about this, but hey, it's good. And also, it also alleviates an appeal issue potentially, because, you know, defense can't argue that, oh, well, we didn't have enough time to prepare for our opening. Judge is going to give them all the leeway they can possibly have to avoid any type of appeal if there were going to be that issue later on.
Oh, that's an excellent point, David. Thank you for that. I want to talk to you some more about Donna Adelson, and will we see her testify? It seems we got a little hint of that in the last hour when her attorney said she will testify to being afraid of Luis Rivera because of his high position within the Latin Kings. We'll hit a break, and then we'll talk some more about Donna Adelson on the other side. We thank you for being with us on this Friday morning.
I've gained more than a third of my body weight here. The diet is all carbs, no protein. I don't have any antibiotic cream, and I don't have a Band-Aid. Borrowing sanitary pads. She said, "You're going to buy me commissary. You don't snitch, you don't tell on anyone, because you'll be sorry you did."
Well, it's going to be some more carb loading for Donna, at least for the next couple weeks, because she's going to be jailed up until the disposition of her trial. And that is exactly what they're talking about in this pretrial hearing this morning. They're starting the picking of the jury on August 19th. And then they're debating when they should start the opening statements. We heard the prosecutor stand up and say they're ready to go right after the jury is seated. Defense counsel is saying they'd like at least a day after that to get ready for them. Let's go back in together now.
Coming on their timelines, I'll just instruct both parties to be prepared to potentially give their openings. I'm not going to place a time limit on the opening statements, but obviously, well, each party will be the captain of its own ship as to how you will captivate the jurors. Is either party expecting their opening to go beyond 30 minutes?
Depends on your ruling, Judge.
Ms. Cattleman.
Yes, I think it could be up to 45 minutes. It's not going to be different than it was previously, but I'm sorry, I don't know how long it was. I would say 30 to 45 is comfortable range, Judge.
Well, as to the defense case, once we are finished with the state's case, how much time are you estimating?
It depends on your ruling, Judge, but anywhere between 4 and 6 days.
4 and 6 days. So that would place us then around the week of September 8th. All right, concerning any other matters that we can address as the logistics of the trial, I believe we will have rooms available for our family members, both for the victim's family and for the defendant. Do the parties anticipate making use of these rooms?
Yes, Your Honor.
Yes, sir.
All right. Please contact court administration. From there, you'll receive information as to how to access the rooms and when they will be made available.
Judge, can I clarify your intentions about when to start testimony?
Go ahead.
You intend to start testimony on the 25th, is that right? With the possibility of openings having already been conducted?
Well, at the latest, if we go into Friday with needing to select a jury.
Okay. If we get a jury...
If we get a jury prior to that Friday on, say, the 21st, really at that point, there's nothing preventing the testimony from getting started on the 22nd.
Okay, so I'll be prepared to start testimony on the 22nd then, and my understanding was, and my subpoenas run through September 5th, but it sounds like we might be extending into the week of September 8th, is that right?
Well, I believe the defense is indicating they might need anywhere from 4 to 6 days.
That's what they said. All right, so we could potentially go through the week of the 8th.
If need be.
All right, I will attempt to get subpoenas out for rebuttal for that week, but I will advise the court that as of right now, those are not out.
We are losing a day because of September 1. But if need be, we can figure out logistically how to make this work for Saturday to continue working. I'm sure you all would like a break, but I'm here. The parties have any matters of logistics they need to raise concerning the trial.
Yeah, Judge, we're going to have an issue regarding space. We're not all going to fit here. We also don't want our computer screens facing cameras and the audience being able to see what's on our computer screens. I have become very old, and the font size I use is very large, and probably someone in the back row can see what I have on my computer. So we're going to need to have, I understand we're blocked by this column,
right,
but we're going to need to have some kind of setup where we can put our things and our defense not be disclosed ahead of time to the media and blogs and this and that. The second thing is these microphones used to have the ability that you could touch it and it would turn off. My client is hard of hearing, so she talks loud. So everything she says is going to be picked up. This one is now set up so you have to press it each time you want to mute it. And
press and hold.
Right, press and hold. You got to hold it down for it to continue to stay muted. And we're going to ask if the court admin could put it back to the function where we can push it off. I don't think there's going to be any opportunity in the trial for someone to not pick up on a recording Mr. Zellman's voice. He's very loud. I tend to be loud too. So it's not going to be a record issue in our position, but it's certainly going to be a problem when we're trying to speak to our client about something because it's going to be heard.
Well, but in front of the jury, I definitely understand the concern that you're registering with this. What inquires to what can be done for the microphone on the table. If your client though does need to write things down, so that way nothing is being given away, that might be the easiest way for that to be handled, but that requires the microphone. The seating set up in the gallery, I believe the first two rows behind the defense, those are not going to be available to any members of the media. As far as the font size on your computer, if you need to rearrange how you're seated at the table, so if you need to seat on the far left, or my right, your left, so that way your computer can face the wall and no one can see it. I don't really know what I can accommodate you with as far as that font size beyond that.
Well, the problem is the end of the table it's not open. It's the leg of the table. So I don't know if we can add a little something, another table that is the same size.
What I've tried a 3 co-defendant first-degree murder trial in this room before, and what we had done was one table was between the column and the bailiff's box. There was a table here and then this table here. I think that if we could put a table to our left, that might be one way of accommodating this need.
Right. Please make a request there in the court, and then we will figure out the best way to try to configure the tables. Ultimately, for what needs to come in with, I believe the state is going to try to, needs to bring in its equipment, audio equipment.
Yes, Your Honor.
All right. Because of that equipment and how that will need to be set up, the tables and how they're configured can't interfere with that, but we'll try to accommodate that as best as possible. Ms. Kappelman, as to the audio or visual needs of the state, other than what has been used before with the audio setup, is there anything that needs to be addressed?
No, sir. It'll be the same setup with the same company.
All right. Probably then they'll need to get started by the 15th in this room so they can set up all equipment, test the equipment, and if there's any problems, we'll be able to figure out what needs to take place.
Okay, now let's pause things here and talk about this concern, the concern of people who shouldn't be hearing the legal matters discussed and the defense discussed at counsel table because of positioning of monitors and microphones. That is a valid concern. Let's talk about that with our legal analyst guest, attorney David Gelman, watching along remotely with us. So David, hearing them talk about this was one of those moments where I'm saying to myself, okay, this I get. And when they're saying we don't want everyone to hear our strategy, we don't want it out there in the media, on the blogs, then I started thinking, ooh, what's the strategy? Is this something we haven't thought of here? Your reaction to all this, please.
My reaction right now is they are extremely high maintenance, this defense team, along with their client.
I'm
honestly.
sure many of our courties do not disagree with you, David. Go ahead.
I've been through a lot of trials before, and I got to tell you, this is a new one. The judge answered it exactly correct. Oh, well, Miss Adelson, she speaks loud, and the other defense attorney speaks loud. That's why you have pen and paper. Write everything down. You can have a couple legal pads. Whatever questions or comments you have, keep between yourself. And then for the font size of the computer, that's a new one as well. I don't know if anybody in the courtroom, is going to be seeing that from a distance, because, where the jury is, where the gallery is to where the defense table is, that's still a long ways away. So unless you have binoculars, I don't know what you're really going to be looking for. So I think this is much ado about nothing, if you ask me.
Mm-hmm. Yeah, fair point, David. And, and I can speak from our perspective at Court TV, we always, and you know this, David, from giving analysis on other trials, we always respect what's going on at counsel tables. We never, ever put up a microphone to listen in or zoom in on a monitor. Never, ever, ever. That's not how we do things. We make sure their privacy is ensured. There's no zooming on the legal pads. If, as you noted, they're writing down, none of that. What other people in the public see, that can't be helped, right? If somebody, courtrooms are public. If somebody wants to come in and they want to vlog or blog, we know that people do what they do nowadays, TikTok about whatever they see, that's up to them. So I hear you when you say, as the court's obligation goes, the judge is doing what needs to be done here, and whatever else happens, it just happens. David Gelman, stand by. In our next segment, we're going to break down what it's going to be like for Mama Donna Adelson to go back on the stand. We saw the hint about that earlier in this hearing. When we come back, we'll look back at what it was like when she testified at one of those pretrials in the not too distant past. We saw her. We got a little sampling of how she may come off. That's next.
The matriarch of the Adelson family gets arrested.
Donna Adelson is facing charges of murder, the death of her former son-in-law, Dan Markel.
Prosecutors say a bitter child custody battle was the motive for the murder-for-hire plot.
Now that Donna has turned into a defendant, what's next for the Adelson clan?
Now that the ship is really sinking fast, blood doesn't matter that much.
The Matriarch Mastermind murder trial. Live coverage begins August 19th, only on Court TV.
Welcome back to Court TV Live. We'll go back to Florida for more of Donna Adelson's final pretrial hearing in just a moment. But first, we have another trial we want to tell you that we're tracking for you. The dismembered wife murder trial in Georgia for defendant Nicholas Casotis. This guy is a former Navy JAG. He's accused of murdering and dismembering his wife, Mindy. Mindy's friend is on the stand right now. This is her, and we're going to get you caught up on all of her testimony coming up for you in our next hour of programming. Now, back to Florida. Let's hear the rest of the hearing.
All right. For the media presence that will be here as well, I believe it will be similar rules as it's been in the past. There will be one live video camera. There will be one still frame camera. Obviously, the bloggers and reporters, they are permitted to take notes as if they were print journalists. But the initial rows behind the state, Ms. Kappelman, I assume the victim's family is wishing to appear.
Yes, Your Honor.
All right. They will receive priority seating with regard to how they're positioned in the gallery. After that, it will be free to the public and the press to seat in all areas that are available. Does either party need to be heard concerning those?
Your Honor, we're also going to need space for our client's family and friends who are going to be coming to support her as well. And we would request that they have similar priority seating as the victim's family.
That's what the two rows will be behind the defense that will be available to family and friends. Again, similar to last trial, other than the video recording and still frame photography recording, beyond that, no cell phones are to be out recording any other matters or trying to take photos of the witnesses or the jurors. I believe similar in the last trial when Special Agent Jimenez testified, His face was not shown, obviously, because of the nature of his past work. The court will just make the same ruling concerning that as well. His face is not to be shown, but of course the substance of his testimony certainly may be reported on by anyone who believes it is newsworthy. During the selection of the jury, the faces of the prospective jurors are not to be shown. Their names are not to be shared. But as far as any biographical type data, such as the composition of the jury, being, for example, 7 male, 5 female, what their professions are, those are certainly able to be reported on by the members of the media and disseminated. But ultimately, what I'm getting at is names and faces, so we don't have any disruption or disturbance during the trial. Do any of the parties have any questions concerning those?
No, Your Honor.
No, Your Honor. One last thing. Typically, I don't think I've had a trial with you quite some time. Typically, my paralegal sits with us, so that's another reason why we need that additional table. She also may have some additional people assisting her, and I'll make sure that they're identified to the bailiffs so that there are no issues there.
The members of the direct support staffs may sit on the benches that are behind the attorneys, or if we need to figure out a table configuration for them, if we have the space. But the direct support staff is permitted as to both sides. Does either party have anything further to raise concerning the logistics of the trial or any other issues before we finish?
No, Your Honor.
No, Your Honor.
One other matter comes to mind if the attorneys can briefly approach.